She didn't even look at me when she said it. She was scrolling through something on her phone, half turned toward her attorney, and she said it like it was nothing. Like it was the most obvious thing in the world. He can't afford representation. He'll fold in the first 10 minutes. Her attorney, a man named Ashford Breck, senior partner at a firm downtown, the kind of guy whose business card felt heavier than it should, didn't disagree. He just straightened his jacket and wrote something on his legal pad. I was sitting 3 feet away. I heard every word. I didn't say anything. I looked down at the folder on the table in front of me, the one I'd been building for 4 months, and I thought, okay, let's go. My name doesn't matter for this story. What matters is that I was 31 years old, I had $17 in my checking account the morning of that hearing, and I was about to argue my own case in front of a family court judge against a woman whose family had been litigating things professionally since before I was born. My wife, I'll call her my wife because that's what she still legally was that day, came from money, real money, the kind that doesn't talk about itself. Her father had built a mid-sized logistics company over 40 years, and when he retired, he didn't sell it. He put it into a family trust and handed management to my wife and her brother. She'd been on the company's board since she was 26. I was a structural analyst. I worked for a regional engineering firm. I reviewed load calculations, flagged design inconsistencies, drove a 6-year-old pickup. I was not by any measure in the same financial universe as my wife's family. When she filed for divorce, she filed fast. 2 weeks after I found the emails, 2 weeks after I confronted her, and she didn't deny a single thing, just looked at me with this flat, exhausted expression and said, I was going to tell you eventually. She had already retained Breck. She'd already had documents prepared. She already had a strategy. I didn't have anything. I had a lease on an apartment I'd moved into 3 days earlier, a box of files I didn't know what to do with, and a legal aid consultation at a community center on a Tuesday afternoon. The attorney I met at that consultation was a tired woman named Patricia. I remember her because she was kind, genuinely kind, in a way I wasn't expecting. She told me the truth without softening it. I couldn't afford litigation against someone of my wife's resources, and if I tried to match her attorney hour for hour, I'd be bankrupt before we saw a trial date. What she said next stayed with me. The only people who beat expensive attorneys in family court, she said, are the ones who do the homework the attorneys don't expect them to have done. I wrote that down. Then I went home and I started doing the homework. The divorce itself, at its surface, wasn't complicated. No children. The house had been purchased with her family's money, title held in the trust, so that wasn't contested. I wasn't asking for alimony. I wouldn't have taken it if offered. What I wanted, what I was owed, was my share of the marital estate, 4 years of contributions, my salary deposited into joint accounts, the investments we'd made together, the equity in a small rental property we'd bought with combined finances 18 months into the marriage. My wife's position, as stated in the initial filing, was that my contributions to the marital estate were negligible and that the rental property, while purchased with joint funds, had been primarily managed and maintained through her family's resources. The number she was willing to offer me was $42,000, a one-time payment. Sign here and we're done. The actual value of what I was asking for, fair market value of my share of the rental property, 4 years of traceable deposits, the joint investment account, was closer to $280,000. She wasn't offering me a settlement. She was offering me a disappearing fee. I didn't sign. She didn't expect that. I want to be honest about the next 4 months because people always want the story to sound cleaner than it was. The truth is, I was terrified for most of it. I'd come home from work, eat whatever was easy, and spend 3 or 4 hours reading family law statutes on my laptop. I ordered 2 textbooks on equitable distribution from a used bookstore. I filled the binder with printed case law. I learned what discovery meant in a practical sense. Not just the word, but how to use it, what I could request, what they were required to provide. I sent formal discovery requests. Breck's office responded with delays in partial productions. I sent follow-up letters citing the specific statutes requiring compliance. They produced more. I read every page. That's when I found the inconsistency. The rental property, the one they were claiming had been maintained through family resources, had its maintenance records in the production. I went through those records line by line. The invoices for repairs, the property management fees, the utility reimbursements. And I noticed that several of the larger expense items, things labeled as capital improvements over the last 18 months, were billed to an LLC I didn't recognize. I wrote down the LLC name and looked it up. It was a shell company registered in Delaware, registered the same month we purchased the rental property. Listed agent, a name I didn't know. But the registered address was the same address as my wife's family's logistics company. I sat with that for a long time. Then I pulled their joint bank statements, all 4 years, and I started matching. Every large transfer out, every home improvement charge, every month where our joint investment contributions came up short by a few $1,000s, and the shortfall coincided with a transfer I couldn't trace. By the time I walked into that courthouse, I had a spreadsheet with 63 flagged transactions and 4 months of cross-reference documentation. I also had one more thing. Something I almost didn't include because I wasn't sure it would matter. Something I'd found almost by accident 3 weeks before the hearing, while going through a batch of documents my wife's attorneys had produced late in discovery. A single email, 1 page, sent from my wife's personal account to Breck's paralegal 7 months before she filed for divorce. The subject line was Asset Separation Timeline. The morning of the hearing, I got up at 5. I showered, pressed my shirt, ate toast standing over the sink. I drove downtown in the dark and I sat in my truck in the parking garage for about 20 minutes just running through everything in my head. I wasn't calm. I want to be clear about that. My hands were unsteady when I walked through the metal detector. I dropped my pen twice at the table. But there's a difference between scared and unprepared, and I was only one of those things. My wife arrived with Breck and a second attorney I hadn't seen before. A younger woman she'd apparently brought in specifically to handle financial documentation. They came in confident. My wife sat down and that's when she made the comment, the one about me folding in the first 10 minutes. The judge assigned to our case was a man named the Honorable D. Carroll. I know his name because I looked him up beforehand. He'd been on the family bench for 11 years. He had a reputation, from what I could read in public records, for being meticulous and impatient with procedural games. He came in, settled, looked at both tables. "Mister," he said my name. "You're self-represented?" "Yes, Your Honor." He looked at me for a moment in a way that wasn't dismissive, just assessing. Then he looked at Breck. "Counsel, you've reviewed the pro se filings?" Breck said yes, with the tone of a man who'd reviewed them the way you review a menu you've already memorized. Confident. Unhurried. "Let's proceed," the judge said. The first part of the hearing was Breck presenting their position. He was good, I'll give him that. He was smooth, organized, spoke with the kind of controlled authority that comes from doing the same thing for 20 years. He framed my wife as the primary financial driver of the marriage, portrayed the rental property as an asset that had appreciated specifically through her family's management infrastructure, and characterized my contributions as those of a supporting spouse, a phrase with a specific legal implication he clearly intended. He submitted their exhibits. The judge reviewed. I took notes. Then it was my turn. I stood up. I heard my wife say something quietly to her new attorney. There may have been a sound. I didn't look over. I introduced my first exhibit, the joint bank statements, 4 years color-coded by category. I walked the judge through the deposit history, my salary, consistent, traceable, representing 44% of total household income over the marriage. I showed the contribution schedule to the investment account. I cited the statute on equitable distribution. I kept my voice even. I didn't editorialize. I just showed the numbers. The judge was looking at the documents closely. He asked me 2 clarifying questions. I answered them directly. He made a note. Then I moved to the rental property. I laid out the purchase record, joint funds, joint mortgage application, both names on the deed. I showed the LLC invoices that had been submitted as maintenance records. I showed the Delaware registration. I showed the matching address. Breck objected. Foundation, relevance. I cited the discovery production batch the documents came from, the Bates numbers, the date of production. The objection was overruled. The judge leaned forward slightly. I kept going. I showed the 63 flagged transactions. Not all of them. I prepared a summary exhibit, 10 representative examples chosen for clarity, with the full spreadsheet attached as a supporting document. Each one had the joint statement entry, the corresponding LLC invoice, and a note on the timing. The judge was quiet for a long time after I submitted that exhibit. Then he looked at Breck. "Counsel," he said, "your client's position is that the property was maintained primarily through family resources. Can you point me to documentation of those family expenditures that doesn't route through this LLC? There was a pause. Breck said they would need time to supplement the record. The judge said, "You've had 4 months of discovery to build this record. We're not supplementing today." My wife's hand, I noticed, had gone flat on the table. I want to stop here for a second because I know what people expect from this kind of story. They expect a dramatic courtroom moment, a gasp, a breakdown, someone dramatically standing up. It wasn't like that. It was quieter than that. It was the sound of a judge asking a straightforward question and an experienced attorney not having a straightforward answer. That's the thing nobody tells you about being underestimated. The bar they set for you is so low that simply being prepared looks, to everyone in the room, like something extraordinary. I submitted the email last. I'd thought a long time about how to present it. I didn't want it to look like a gotcha. I didn't want the judge to feel like I was grandstanding, so I presented it simply as a document in discovery production, exhibit number 14, and I read the relevant portion aloud without commentary. The email, sent 11 months before she filed for divorce, outlined a proposed sequence. First, begin routing maintenance expenses to the family LLC to establish a paper trail of family contribution. Second, initiate a transfer of the rental property's management rights to the LLC. Third, once those transfers were established, file. The subject line again, asset separation timeline. The judge read it. He read it twice. He asked my wife's attorneys whether they disputed the authenticity of the document. Brett conferred quietly with his colleague. Then he said they did not dispute its authenticity. The judge set it down. He looked at my wife for the first time in a while. She was looking at the table. This document, the judge said slowly, suggests that the financial arrangement your counsel has characterized as organic marital history was, in fact, a planned restructuring initiated before the filing. Is that a fair reading? Breck started to respond. The judge held up one finger, not rudely, but with a finality that stopped Breck mid-syllable. "I'm asking Mrs.," he said my wife's name. She didn't answer for a long moment. Her attorney touched her arm. "I'd like to consult with counsel," she said. "Of course," the judge said. "We'll take 15 minutes. During the recess, I sat at my table, and I didn't move. I wasn't celebrating. I wasn't sure yet what was happening. I just sat there with my hands folded over my folder and I breathed. One of the court clerks walked past me on her way somewhere. She caught my eye and gave me a small, almost imperceptible nod. I held on to that. When we came back, Breck's posture had changed. It was subtle. He was still composed, still professional, but something in the set of his shoulders was different. He stood and he said that his client wished to reopen settlement discussions. The judge said, "We're past opening discussions, counsel. I'd like to hear from both parties on the question of asset valuation before we proceed." What followed was 2 hours of detailed financial testimony, a lot of it dry, a lot of it numbers I'd already memorized. Breck argued depreciation. I cited appraisal comps. Breck argued management attribution. I cited the ownership record. Twice the judge asked me follow-up questions that suggested he'd read my exhibit package carefully. Once he cited, from memory, a page number in my summary document. At one point, Breck referred to my methodology as amateur analysis. The judge looked at him. "It's documented, sourced, and internally consistent," the judge said. "I'm not sure what the objection is." I didn't say anything. I looked down at my folder. The judge didn't rule from the bench that day. He said he'd issue a written decision within 30 days, which is standard. We were dismissed. I packed up my folder and walked out. In the hallway, my wife walked past me with Breck and the second attorney. She didn't say anything. She didn't look at me. Breck, to his credit, glanced over and gave me a brief nod. Professional acknowledgement from one person who'd done their work to another. I drove home. I picked up a burger at a drive-thru because I hadn't eaten since the toast at 5 in the morning. I ate in my truck in the parking lot of my apartment complex, and I called my brother and I told him what happened, as clearly as I could. And then, I didn't say anything for a while, and neither did he. "You okay?" he said eventually. "I think so," I said. "I don't know yet." The written decision came 26 days later. I opened the email on my phone in the break room at work, which was probably not the right setting for it, but that's how it happened. The judge found in my favor on equitable distribution. My share of the rental property, valued at current fair market, not the depreciated figure Breck had argued, was awarded as a buyout. The joint investment account was split 50-50 with no deductions for management contribution. My 4 years of traceable deposits were recognized in full as marital contributions. The total award was $261,000. There was also a section at the end of the decision, 3 paragraphs, that I've read probably 30 times since. The judge noted that the documentary evidence suggested the asset restructuring had been initiated in anticipation of dissolution proceedings, and that this pattern warrants further review by appropriate authorities. He didn't use the word fraud. He didn't have to. He referred the financial records to the state attorney's office for review. I don't know where that review stands. I probably won't know for a long time. That part isn't my story to tell anymore. People ask me sometimes what the moment felt like. The moment I knew it was going to go my way. I never know how to answer that. There wasn't a single moment. It was more like a series of small ones. The judge's first clarifying question. The overruled objection. The 15-minute recess. The nod from the court clerk. What I know is that my wife walked into that courtroom expecting me to be unprepared, and preparation was the only real weapon I had. I didn't have money. I didn't have a law degree. I didn't have a family with 4 decades of litigation experience behind them. I had 4 months of evenings. I had a binder. I had 63 flagged transactions and 1 email with a very clear subject line. She laughed when I sat down at that table alone. I thought about that laugh every single night for 4 months. Not with anger exactly, more like fuel. The kind that burns slow and even and doesn't go out. She stopped laughing around page 4 of my exhibit package. The judge didn't stop reading until he'd gone through all 14. I've thought about what actually happened in that courtroom a lot since then. Not the numbers, not the legal language, not even the judge's written decision, though I've read that 30 times too. I mean, what actually happened. The mechanism of it. My wife didn't lose because the judge was generous. She didn't lose because I got lucky. She lost because for 11 months before that hearing, she operated on a single assumption, that I wouldn't look, that I'd be too overwhelmed, too broke, too beaten down to go through 4 years of bank statements line by line at 11 o'clock at night on a Tuesday. That assumption was the most expensive mistake she ever made. That's the thing about contempt. It makes people sloppy. When you're certain someone beneath you won't fight back, you stop hiding things carefully. You leave emails in Discovery Productions. You register show companies at the same address as your family business. You don't bother because you've already decided the outcome. And then the person you underestimated shows up with color-coded exhibits and 63 flagged transactions, and suddenly, your certainty is the thing that buried you. I'm not saying I'm exceptional. I want to be honest about that. I'm a structural analyst. I read documents for a living. I know how to find inconsistencies in dense technical records. That's not a superpower. It's a skill set I happen to have, and I used it. Most people in my situation don't have that specific background. But most people in my situation also don't spend 4 months reading family law statutes at midnight. The preparation was a choice. The hours were a choice. Every time I wanted to close the laptop and go to sleep, staying open was a choice. Patricia told me at that first consultation, the only people who beat expensive attorneys are the ones who do the homework. The attorneys don't expect them to have done. I kept that because it's true, and it's true about more than courtrooms. The gap between what someone expects from you and what you actually deliver. That gap is the only leverage a person without resources ever really has. You can't outspend someone with generational wealth. You can't outprepare them. You can outdocument them. You can show up having read every page of every production they sent you, having cross-referenced it against 4 years of statements, having found the one email with the subject line that unravels the entire narrative they spent months constructing. That's not dramatic. It's not cinematic. It's just time applied carefully in a direction nobody expected. What I think about most is the version of me that signed the $42,000 check. He almost existed. There were nights in that first week after she filed when I came very close to convincing myself it wasn't worth it. That the fight would cost me more than I'd ever recover. That I should take what was offered and start over. I understand why people make that choice. The weight of going up against someone with more resources is genuinely crushing. And not everyone has 4 months of evenings to give. But I also know what I would have carried if I'd signed. Not just the money. The knowledge that I let it happen without looking. That I handed over 4 years of my life because the other side counted on me being too tired to read the fine print. I wasn't too tired. She stopped smirking on page 4. The judge didn't stop reading until page 14. That's the whole story, really. Not justice as a grand concept. Just, I did the work, and the work was enough.